Welcome back to Ojukwu News Channel, where we break down the most critical legal and political issues shaping Nigeria and Africa. Today, we're diving into a landmark development. A Kenyan High Court ruling has declared that the arrest and transfer of Nnamdi Kanu to Nigeria was illegal. But beyond the headlines, there's a bigger question. Does Nigerian law itself say that Kanu's trial in Abuja is fundamentally invalid? Let's find out. First, let's be clear. Nnamdi Kanu, the leader of IPOB, was abducted in Kenya without any court extradition order. Kenya's High Court ruled and said that this has violated Kenyan law and international human rights treaties. But here is where it gets even more serious. Nigeria's Terrorism, Prevention and Prohibition Act 2022, Section 2(3)(f)(2) defines terrorism to include an act which is deliberately done with the intention of kidnapping or abducting any person contrary to international law. Let's read it clearly loud again. Nigeria's Terrorism, Prevention and Prohibition Act 2022, Section 2(3)(f)(2) defines terrorism to include an act which is deliberately done with the intention of kidnapping or abducting any person contrary to international law. This means that any abduction outside, which is of proper legal process, like what happened in Nairobi, is itself defined as terrorism under Nigerian law. If the process of bringing Nnamdi Kanu into Nigeria is itself illegal, and in fact classified as terrorism, then any subsequent trial is tainted by that illegality. There is more to this. Article 12(4) of the African Charter says, a non-national, legally admitted in a territory may only be expelled by a decision taken in accordance with the law. In Kanu's case, no such lawful decision ever happened.
So what does this mean? 1. It means that under Nigerian law, the method of bringing him here is legally invalid. 2. Under African and international law, it's also prohibited. 3. Logically, if the process of arrest and transfer is criminal, then Nigeria's courts lose the moral and legal foundation to continue the trial. Many legal scholars argue that if any trial were to occur, it should be conducted in a neutral country or under international supervision, to ensure due process and restore legitimacy. In fact, precedents exist. When extradition is illegal, some courts dismiss charges outright, others refer the matter to international tribunals. This is why IPOB's lawyers are demanding that Nigerian courts suspend the trial and consider international remedies. Their position is simple. If Section 2(3)(f)(2) defines abduction as terrorism, and Article 12(4) forbids expulsion without lawful process, then Nnamdi Kanu cannot lawfully be tried inside Nigeria. What do you think? Should Nnamdi Kanu be tried outside Nigeria? Should the court dismiss the case? Drop your thoughts in the comments below. Don't forget to like, subscribe, and share this video if you believe in justice and the rule of law. Thanks for watching Ojukwu News Channel, your source for the truth behind the headlines.